true or false. Okay, let me show you. All right, true or one set is true or false question. The other set will be multiple choice question. Now at the end of each question, I will show you the correct answer. So yeah, so then it will last about an hour or so. Now it depends. It depends on how much or how many people are watching. So let's say there are quite a lot of participants at the quiz show. So what we will do is that we'll pull out the poll. Today being the exam day, people are right now taking the exam. So okay, I may not use the poll. Let's play by the ear. Now, before we start, let me just say a very quick prayer for those people who are taking exam right now. So, Father Lord, we just want to welcome your presence here at our quiz show. So we just pray that your presence here will help us to pick the right answer and also to know exactly the concept behind the questions that we are studying. And for those who are taking exam, Lord, I pray that you'll bless them abundantly with good results. For those who are practicing this business, I also pray that you'll bless them with fruitfulness. So in Jesus' name, I pray. So now let's start. Let's start the quiz show. Now let's do true or false first. The first question: in the event of a foreclosure by the mortgagee. Now, foreclosure means the mortgagee will then stop you from redeeming the security. So mortgagee means the bank. Now, all tenants will be relocated as the mortgagee is not bound by the covenants of the tenancy agreement. Very general statement. So you really got to dig into your own conceptual understanding. So now let's try. Let me launch the poll. Okay, today, because we have a very small number, so I think I will just give you 10-15 seconds to do the poll. We also have audience at Facebook. So audience at Facebook can actually just put in the, you can just text in T or F. All right, so now the answer from our poll, our Zoom poll, is false. Now, what about my own answer? Let me show. Yeah, of course, it's false. Now, there are certain conditions. It all depends. Now, tenancy will only be voided when the mortgagor, that means the landlord, had not sought the mortgagee's consent to let the property. Now, you see, when a property is bought for own enjoyment, usually when you approach the bank for a bank loan, they will give you a different form, an application form. So basically, the bank will give you more goodies. Example, there will be a lot of preferential rate, some discounts and all that. Now, so at the end of the day, when you take key to the apartment, you may decide to rent out the property without telling the bank. Now, the bank can actually penalize you because you say you for own stay, so that's why they give you a lot of goodies. Now, so what happened when you approach the bank? You told the bank that, oh, this one is for investment. I'm not living there. So what happened is that they won't give you a preferential rate already. So they will probably give you slightly higher interest. So now, so for formality's sake, when you want to rent out, you will still tell them that, okay, I intend to rent out. So, but usually once you look at the loan term, you already know, the mortgagee already know that, already given you the consent, so to speak. So now, corporate leases, usually the tenant who is a corporation will insist on non-disturbance clause. So this is the reason why for practicing agent, especially when you are new, so you will find that sometimes when you have a corporate lease, you think that, okay, owner will be very happy dealing with corporate lease. But sometimes the landlord will say, no lah, corporate lease, corporate lease, what's so big deal? Don't want, so troublesome and all that. Now the reason could be because they have no mortgagee consent. Okay, they say, oh, very leceh lah, this, okay, no lah, actually they know the consequence. Second question, let's try. The replacement tenant was willing to pay only 8K per month, while the outgoing tenant was originally paying 10K per month. So the takeover deal cannot go through. True or false? Now let me call out the poll question, and let's vote. Now for those who are on Facebook Live, you can also text in. All right, so now let me, okay, now on Zoom, the answer came in true. Now let's see whether this is correct or not correct. Let me show you my answer. It's false. It's false. Now the reason is because the original tenant, all right, will top up the difference. So in our scenario, it is you know, the replacement tenant say, I will only give you $8,000 per month. So now, so if let's say the original tenant say that, okay, I will lose $2,000 per month rather than I keep paying $10,000 per month, and then my business is no good. So is between for the consideration for the original tenant is losing between 10,000 or losing 2,000. So he may say, okay, never mind, I just top up 2,000. I go and drive Grab or I become a Grab food delivery driver. Okay, so you know, now let me give you an example. The original tenant had 8 months left in the original lease, but the replacement tenant wants to sign a fresh lease of 3 years. So now what happened is that the topping up of 2K every month will be for the remaining of the 8 months. So the period where I assign, then I'm responsible, I will top up. Now thereafter, the original tenant will drop out completely. Because why? Because his lease ended already. So the replacement tenant will continue to pay 8,000. All right. I mean, of course, he paid 8,000 from day one, but it's just that for 8 months, the outgoing will top up. Okay, so I suspect right now we will have a lot of this kind of retail lease. Office lease, I think after a while, it will go up. I mean, if you follow my analysis for the past few months, I was saying that once the pandemic is over, Singapore will then go back to bull run. But it looks like now it's quite true. So you can see that economies, the last few days, this week, the last few days, you can hear all sorts of commentator saying that we will recover very quickly. So following the previous question, that means the assignment. Now the outgoing tenant and the original landlord will sign the assignment agreement. So now let's pull out the poll question for you to vote. Now let's vote. All right, thank you very much. Let's show the, okay, on Zoom. All right, the people here say it's true. So now let me see. Now this is a conceptual understanding. Conceptual understanding. It's false again. Now the assignment agreement is signed between the okay, the assignment agreement is signed between the assignor and assignee. That means the outgoing tenant and the assignee. Now between the original tenant and original landlord, they will sign a novation agreement if there's a shortfall, if there's a shortfall in the rent. Now, if let's say there is no shortfall in the rent, then okay lah. I mean, you come in, you want to take over my whole lease, I will drop out of the picture altogether. So once you see novation agreement, means that the original tenant already out. Now, let's say there is an assignment agreement, that means the original tenant is still inside the contract. Now, let's try question 4. Lock one room is a form of derogation from the grant. So this is theoretical. No choice. When you are preparing for exam, you still have to remember all the theory. Let's see. Let's vote. Okay, 10 seconds. Okay, people on Zoom say it's true. Let me show the answer. It's false. It's false. It depends on what has been agreed. Now, unless there's no prior agreement to lock one room, I'm not teaching the newcomers how to go around HDB rules. Now, for a lot of people, when they haven't met their MOP, they still rent out, but they sign a room rental agreement rather than whole flat subletting. But they still flout the rule because the rule says that you must live inside. So they're talking about not possession, they're talking about occupation. HDB talks about occupation, minimum occupation period, and not minimum possession period. Because if you're not living inside, you are still deemed to be in possession of the property. So that does not count. Now let me read out the answer to you. If there is an HDB whole flat subletting, then lock one room is a circumvention of the HDB's MOP rule. Now, in other words, the flat owner is contracting on room rental. Now, if you say that this is room rental, then I can lock 2 rooms. Then there's no issue already. So it depends on the context. Now, so private apartments, then there's no such thing. So private apartments, when you rent, you have to open up all rooms. If not, then there will be derogate from the grant. Or some private apartments, they go and lock the escape, fire escape staircase. Now that is very dangerous also. Okay, let's try question 5. A foreign tenant or foreigner tenant can rent a bungalow for a term of 10 years and renewable for another terms of 10 years. Rent, it never say buy, it say rent. Let me call out the poll. This is a trick question. Let's vote. All right, so people on Zoom say is false. So let's let's go to the answer. It's false. Why? Now, lease of 10 years will confer the leasehold estate to the lessee. You become a lessee, not a tenant. Now, it's subdivision of the property, and also is a partition of the title, so to speak. Means that subsidiary certificate of title, right? SCT, not SSCT. Now, once you lease the airspace, you got to grant the subsidiary title. Subsidiary title. All right, not strata title, subsidiary title. Now, so subsidiary certificate of title is a title for leasing of airspace. Leasing of airspace. Now, so that is what I call it. So that is granting of a leasehold estate. all right, as opposed to a 3-year tenancy or 5-year tenancy. Now, I like to use WeWork as an example. So for people who are familiar with WeWork rent office, they rent maybe 20,000 square feet or 10,000 square feet. They rent for 7 years. Because why? Because they don't want anything on their balance sheet. So that's why when they rent 7 years, it is still a tenancy. So they are not considered the owner. So they are considered asset light. Asset light. So, but a lease of more than 7 years means 7 year, 1 day. We don't see this kind of lease. So usually we will see a 10-year lease. Or that's different already. Then on your balance sheet, you will have a property on your balance sheet. So, okay. So for residential property, a foreigner who has not obtained any special approval from the land dealings approval unit under SLA, they cannot go into a long lease of a landed property. That will be circumvention of the rules. Let's try question 6. A factory operator who rents the factory for a term of 10 years will have to pay maintenance fees, insurance, and property tax. This is according to whatever you have learned from RES course. So let's do the poll. For those who are on the Facebook, you can't see the poll, the Zoom poll. All right. So this is I mean, on Zoom, people say is true. Let me share the results on Zoom. You can't see these, even though I'm recording on Zoom. After that, when I play the recording, I can't see this. All right, so now let me show you the answer. It's true. So now let me explain. Now this is because a lease term of longer than 7 years confers the leasehold estate to the lessee. So making him the current owner, so to speak. So now this kind of leases is called the triple net lease. Triple net lease. So the lessee will have to pay everything, and then the lessor does not have the responsibility to pay property tax, to pay maintenance, or to pay insurance anymore. Then of course, we are referring to a strata unit. So as the owner, the lessee will have to make monthly contribution to the management corporation if it is a strata factory. So he will end up becoming the owner. Then the owner will have to pay property tax and insurances. Let's try question 7. An oral lease is presumed to have covered the usual covenants in the lease. You all do the poll first. Then I will explain. Because now, okay, never mind. Just vote first. Wait. Sorry. How come? Let me try again. Sorry, poll is closed already. It doesn't matter. I hope you don't mind. I made a mistake just now. Okay, let me show you the answer. Okay, you have your answer in your heart first. So let me now show you the answer. An oral lease is presumed to have covered the usual covenants. Now, even in an oral lease, the tenant and the landlord are presumed to have agreed to the usual covenants. Let me explain what is usual covenant first. Then I want to go back to what is being practiced right now in the industry. Now, the usual covenants, there are 4 or 5. I'll just show you 3 here. The usual one, tenant paying rent. So that will be on the tenant side. Landlord paying taxes and insurances. And of course, maintenance. Okay, so then you have both sides. Now, keeping the premises in repair, also both sides, because tenant will be minor repair. Repair, the word repair means in good condition, in serviceable condition, So the landlord will also have to agree to that, because if a major repair, then will be the landlord's responsibility. Now, allow landlord to enter and inspect the premises if the tenant requests major repair. So that's for the purpose of repair. All right, and restriction against subleasing and assignment. Last week we have a question on this one. Let's say you are not allowed to sublet and assign, but what happened? You really have to. So when you really have to, then you go and ask the landlord. When the landlord gives you permission, then you will be able to sublet and you will be able to assign. So now that situation is called license to sublet and license to assign. So we did that last week already. Yeah. So, okay. Now, what do I want to explain to you? What is being practiced in the market is that CEA has come up with the template. Now, CEA say it's not mandatory. You can disregard the template. Say, for example, corporate lease, and then the corporate insists that they want the landlord to use the corporate version. So if the landlord is desperate, landlord will say, okay, never mind, let's take a look. If he's agreeable, then agreeable lah. So then you don't have to use the CEA one. Now, so CEA will have about, I think, 20 over pages explaining the covenants, even though they never use the word covenant. So I have done that as an update for my RES courses. So what I'll do is maybe next year I will do a CBD course on this one. Okay, I'm not sure lah. Okay, if you're a practicing agent, you're very familiar with the rules in the CEA format, but you may not know the explanation behind. So like, for example, usual covenants. I don't think practicing agent will be very familiar with usual covenants. Okay. So now let's go to the last question on true or false. Now, in an oral lease again, in the oral lease, the landlord is deemed to have the proviso for re-entry on non-payment of rent. This one, if you watch my video, then you will know that I've explained quite a lot. But even my own students, I never mentioned this in class. Okay, now let's do the poll for those who are on Zoom. Okay, I think you got the right answer on Zoom. Okay, let me stop the sharing on Zoom and show everybody what is the correct answer for this question. Is true. Okay, a proviso is a qualification. It means that if something doesn't happen, then the landlord's rights arises. Re-entry means what? Re-entry means kicking out the tenant, no? Means eviction. It means repossession of the premises. So now, of course, you must agree to it lah. You must say it first to say that okay you must pay rent. Is you 3 months never pay rent, then I'll kick you out. So this is called a proviso. A proviso. It's the opposite of covenant, but in operation, it becomes the same. Because why? Because then you give me right to kick you out. But it's just that it happened in the opposite way lah. If you don't do this, then I have the right. All right. So now, right now on my website, I have this web page just for exam preparation. So I have 10 videos, and I have 30 multiple choice questions, which is different from what you are practicing right now. So plenty of free materials for you all to practice. Then after that, I just hope that you benefit from the material, and then you will continue to buy the more than 1,000 multiple choice questions, and you also will buy the lectures, the e-revision material. So you have all the lessons on video. Now, if you like the way I explain, if you like the way I dissect the questions, then you will know that in the videos where I talk in detail, when I discuss in detail the concepts, I hope you like it. I mean, you know that I'm a capable trainer, so you can listen to the video again and again. And of course, you can also practice on the MCQ. So when you buy the MCQ, you're actually practicing the MCQ on my website, on my website. So I'll give you, I mean, for this batch, I give you all the way until you pass the exam. I mean, from next year onwards, then I have to restrict to 90 days. Okay, now let's try some scenario questions. Now, during the COVID-19 lockdown, Aseng took in his Malaysian worker, Ahwat, to live with him. Aseng put Ahwat up in the storeroom of his kampong house. So I believe we still have some kampong houses, just probably a very small pocket. Now, as both of them are in the construction business, Ahwat brought in his tools and a barrel of corrosive liquid and placed them where he temporarily put up. Where he sleep, he just put, because why? Because he's in the shed, in the storeroom. So one day, Aseng's young son accidentally toppled the barrel and damaged the floor. So now when you do the MCQ, you have to remember the scenario, because the scenario cannot appear again. So what is Ahwat's legal status in the house? Let's do the poll. So he's a Malaysian worker right now, staying with in the colleague's house. So okay, is he a periodic tenant? Is he a tenant at will? Is he a licensee? Is he a beneficiary of a resulting trust? So people on Zoom say is a licensee. Let me share the result. For those on Facebook, you can't see anything. Okay, now let me show you the answer. Of course, it's a licensee. Now, what's the meaning of beneficiary of a resulting trust? Now, this one we have discussed last month. Resulting trust we have discussed last month, but I think I need to explain here very quickly. If you have given money to someone to buy a house, and the person later on sell the house, now, so you have the rights to actually call back the money. Because why? Because you are a beneficiary of a purchase money resulting trust. Because the person who owned the house is deemed to be keeping the money for you. So therefore, he's a trustee. You are the beneficiary. So, I mean, it's okay. So it's okay because we are practicing as an agent. We're not practicing as a lawyer. So we may not need to know the details. So when somebody quarrel over this one, then we refer them to a lawyer. But privately, we can tell them, okay, a trust has a situation of trust has a reason. So I need you to consult a lawyer. But I can tell you some of the case law, okay, but I'm not a lawyer. Okay, when an employee lives in the accommodation provided by the employer, it is usually on the basis of a license, and then is on the basis of rent-free. Okay, or maybe they will say, I cut from your salary. So if you have picked A, let me explain A. A is a wrong answer, of course, as this was just a temporary measure. So there was no mention of a valid contract. All right, so it can't be a periodic tenancy. By the way, periodic tenancy only happens after a former lease expires. You can't straight away go into a periodic tenancy. B, there could be an arrangement of tenancy at will between employer and employee. Usually that will involve a longer stay. But in Singapore, we don't see tenancy at will this way. Say, for example, you buy a house and then you say, hey, can I move in early? So the early move in period is called tenancy at will. C, there is no purchasing power, purchasing money involved. So I already explained this one. Second question, was Ahwat answerable to the damage done to the floor? Because why? Because it's the boss' son who toppled the corrosive substance while he's not around. So now is he answerable? So now, I mean, of course, legally let's vote. Let's vote. Those on Zoom can vote now. So the answer is no, he was not a tenant. That's why there's no written rule for him to follow. B is no, it was not his fault. C, no, he's an employee. So he put the stuff there and then another person come and knock it down. D is yes, he owed the duty of care to secure the bearer safely. People on Zoom vote for D. So now let me show the answer. Is D. All right, so now let me help you recall the scenario. Now he brought in his tool, he brought in the corrosive substance because they are contractors. So when they renovate a place, they may need to wash the floor and all that. So then they bring the corrosive substance. And it wasn't him who toppled the barrel and damaged the floor. It was someone else. So now we want to know, you have been allowed to stay at a place, not your place. So you bring your work tool there and somebody damaged that place when you're not around. So are you responsible? So now we want to know that there is no tenancy agreement. Or even if there is tenancy agreement, you say, but if someone else come into my room and topple it, so you cannot blame me. Then you say, no, the contract is here. No, now other than contract, you still owe common law duty of care to each other. Okay, so for example, thoughts of nuisance, for example, thoughts of nuisance, you start to quarrel with the neighbor, you start to make life very difficult for the neighbors and all that. Then you say, no, that's not in the tenancy agreement. No, this is called duty of care. You're supposed to keep peace. Okay, so in this case, it was Ahwat's duty to secure the bearer safely. So that's called duty of care. Okay, so though there was no written agreement, you still bound by common law duty of care, which is very important. That's why you see that I emphasize this again and again. Now, if this is the workplace or relating to Ahwat's vocation, then his boss is responsible. That's called vicarious duty. But this is not a workplace. The boss brought him home to stay in the storeroom. All right. So you must not forget. You must not forget. You say, oh no, law by law is just tenancy. No, it all depends on, is this a workplace? Workplace, I have the duty of care, as well as the boss will have vicarious duty to answer for the employee's mistake. Number 3, question 3, landlord and tenant fought over lease renewal with the landlord serving eviction notice and tenant claiming he has the right to remain on same rent. Court hearing was 2 months away because of COVID-19, and tenant refused to pay rent. Now, in the interim, what do we call the tenant? Already served eviction notice. Landlord already say, I don't want you. So now let's vote. Those on Facebook can't see. You can't see the question, the poll question. This one should be easy. Through the process of elimination, is not trespasser. Can never be trespasser, because he was originally he was already a tenant. Cannot be tenant in common. Because tenant in common is a very different thing. All right. So now the answer has been in. So now let me show the answer on Facebook. Tenant as sufferance. So because when you have been served the eviction notice, straight away you become tenant as sufferance, but you want to fight the case. So now you got a court date. A tenant who remain on premises after lease expires without rent and without landlord's approval or consent. If you pick A, tenants in common is a joint ownership of property by shares. B, if you pick B, a tenant who remain on premises after lease expires without rent, but with landlord's consent. Now that will be tenant at will. Now if you pick D, tenant appear like one but not tenant. Once you are tenant, and then you overstay the courtesy, you will never be a trespasser. All right, so that you must be called a name so that when there is a judgment against you or judgment in your favor and all that, so the compensation will be appropriate. All right, so now let's look at question 4. The factors that a commercial landlord needs to consider. Let me pull out the poll question. Give me a bit of time. Okay. This is a practical question. Let's vote. Okay, the answer come in very quickly, all the above. So now I have to explain what are the things there, A, B, and C. Yeah? Of course, it's all the above. Let me now explain. Now, there must not be a tenant that drive away other tenants' business. For example, vices. Now, so therefore, tenant mix. Tenant mix is what we mean. So B, there must not be too many similar products or merchandises. Similar, then you cannibalize them yourself. Unless you are in a theme shopping center, for example, Sim Lim Square. Now, even I think Funan Lifestyle Mall, they also keep a balance in the trade mix. So, like for example, spectacle shops, you may have like 2 or 3. Goldsmith shop, you may have 2 or 3. All right. I mean, I can't imagine in Singapore, you go into a shopping center where you see everybody is a spectacle shop. Now that will be a theme shopping center. That will be like a wholesaler already. So that's why tenants mix, merchandise mix is very important. Okay, I mean, sometimes in class we only talk so much about tenants mix, but we forgot about merchandise mix. So you will see that now if you go to US, those lifestyle premier fashion mall, okay, it's unusual to see there's no Levi's, because I went to one of those in very near Vegas. They say the tour guide very funny. The tour guide just told us this one got no Levi's, no. So then when I went in, I said, how can you have no Levi's? Okay, so there's a very poor merchandise mix. Number 5, when a tenant owes rent for more than 3 months, the landlord will commence what kind of process? This one is straight from the course notes. So I don't believe you will have a problem with this. Okay, let's take the quiz. Okay, now let's end the poll. Let's share the poll results. Now, those on Zoom, this is not the correct answer. You don't straight away evict. You want to claim back the money first. So the process is called distress process. Distress process. Now, distress process covers the application for court's summons against delinquent tenant, followed by seizure of valuables and auction on site. Auction on site. Now, I mean, some of you heard my story. In my last failed venture, the landlord actually it's a very nervous process. I mean, for me, I was trying to bring back all my personal belongings, such as my Apple, and then my own camera and all that. So I went back to the office at night. Wow, the security guard spot checked me. I said, no, sorry, this is all my personal item. You have no right to stop me. So anyway, re-entry may follow, and the premises may be repossessed by the landlord if tenant remains delinquent. But do you know what? The tenants can actually go and apply for an injunction, no? Because you cannot just seize my tool of the trade, for example. Okay, so if let's say the tenants still want to fight for survival, so they will get injunction. So it's not an automatic process. Repossession is not automatic, sure win one. No. Okay, landlord may not always succeed in eviction. Tenant may be able to obtain an injunction, like I just mentioned. All right, so okay, so especially if the landlord a bit only, I want to chase people out during the bull run, for example. Okay, let's have another scenario. At the same time as an original tenant became uncontactable, the landlord sold the property to a new landlord. So now this is a problem sum. As this happens, the assignee wanted to renew the lease, citing the option to renew in the original lease. But the new landlord objected to it based on the original tenant's abscondment. He absconded with the rent. So now this is question 6. Now what happens when an outgoing tenant who has just assigned the lease to the replacement tenant defaulted on rent? Let's vote for this one. Let me call out the... Okay, let's vote. Okay, answer A says the outgoing tenant has already dropped out of the lease. Answer B say the replacement tenant will pay on his behalf. Answer C say the remedies are contained in the lease as the outgoing tenant is still bound via privity of contract. Answer D say the assignee is now responsible to pay the rent directly to the landlord. I suspect practicing agent will say D. This thing is not in the course notes. This is a little bit practical, but I mean, this kind of thing we always say refer to lawyers. So let's wait for the answer to come on Zoom. I think my audience on Facebook has all left. Okay, so people on Zoom pick C as the answer. Let me show. Now, even though there's a scenario, but we cannot write out the scenario in all the final detail. So because the scenario is to test your conceptual understanding. The conceptual understanding is that after an assignment, the outgoing tenant is not free from the obligations of the lease. He cannot disappear. He is still contractually bound via privity of contract. Because it's just an assignment, he only signed the assignment agreement with his assignee. Legally, he's still answerable to his landlord. All right, so now, if you pick B and D, it is presumed that the original tenant had gone missing or become uncontactable. Contractually, there is no relationship, all right, no relationship between landlord and assignee. So these are two separate incidents. So we don't have the final answer to what happened. We want to go back. We want to say that you will go back to the contract and see what is inside. Now, is it right for the new landlord to deny the assignment? What I call it? To deny the assignee the right to renew the lease because the original tenant went missing. Okay, so now let's answer the question. Let me call out the poll. Okay, answer A says that the covenants of the original lease run with the land and bound the landlord and the assignee. When the original tenant went uncontactable, the covenants of the lease lose their effect. Once the tenant defaulted, the landlord will not be bound by the covenant anymore. The assignee's rights to renew also depends on the original tenant not breaching any of the covenants. So now we wait for the answers to come in on Zoom. Okay. Okay, let me show you what is the answer. The covenants of the original lease run with the land and bind the landlord and the assignee. Of course, provided, of course, the landlord has given the license to assign. There's no reason for the original contract to be varied as the assignee is using the premises, the actual premises. So remember the assignment process, you must go to the landlord to say, hey, can I assign? Then as long as the landlord has granted the license to assign, that means the landlord knows that, okay, this guy is using on behalf of the other guy. So the covenants are assignable to the assignee. That means, okay, you must pay rent. As long as you pay rent, I will allow it. So the situation is different if the assignment is illegal. That is a different story. Okay, so then of course, the whoever is using the premises will then make arrangement to pay the landlord. Okay, last question. A Tibet store in a shopping center successfully negotiated to put in a termination clause in the lease. The termination clause says that in the event that the food court in the shopping center was to be relocated to another floor, then the Tibet store, all right. Okay, anyway, once I say this, you know the answer. What is this contractual term known as? Meaning, okay, if you relocate, then I have the right to terminate. So what do you call it? Is it a precondition? Is this a condition precedent? Is it condition subsequent? Or is this early termination clause? It is a form of early termination, but what do you call it contractually? Okay, this one should be easy. All right. Now, of course, you got precondition, you got preceding condition or condition precedent, or you can subsequent condition or condition subsequent. All right. Now, condition subsequent allows the tenant to terminate the lease when the condition no longer exists in the lease. You have to ask for it. Say, for example, you say, okay, the anchor tenant cannot move. If the anchor tenant no longer in operation or the anchor tenant relocate, then I want to follow, for example. Then I want to follow. If you have no place for me, then I will terminate. Things like that. These are just examples. Okay, so precondition may be agreed upon between landlord and tenant before the contract was made. For example, the landlord say, don't worry. I will repair this, I will repair that. When you come in, this one will be okay. This is called a precondition. All right. So what is then the preceding condition? Preceding condition is implied. For example, deposit and down payment are considered preceding condition. Means that when you come, you pay me 1%, and I grant you an option. All right. So I will take it that you have already gotten the bank's approval, loan approval. Okay. They call it what? Conditional approval. So that I would think that you have the money to buy my house, no? So that is a preceding condition. It's implied that you already get the financial means. You have the financial means to complete the sale. So okay. So now let me read the whole thing. Preceding condition is implied. For example, buyer, okay, the deposit and down payment are considered preceding condition when a buyer or a tenant comes forward to make an offer. So it is unspoken, unlike a precondition. A precondition, you agree that, okay, example I given was you agree that you will renovate the place. For example, you agree that you repair certain thing. Okay. All right. So now next week, we will have our 4th quiz show for October. And remember, we have a 31st October. So that week, we will not have any quiz show. So because I only prepare 4 for a month. Okay. So I hope that if you have friends who are still struggling with passing the exam, ask them to come to my website. We have the exam preparation. We have free resources for you. And of course, we will promote our e-learning resources, which is a paid resource. All right. So this is end of the game. I hope that you have been blessed. So I see you next week. Thank you very much.